I think there isn't so much chit chatter because we're all bummed about the game last night. It's all right. We're a great road team.
We are now live.
I hope Commissioner Lerner's not having a problem because she was on, wasn't she? Yeah.
Why did everybody's picture go? There you go.
Hey, Mark, I'm wondering if you're gonna, change up your screen, your backdrop, just out of deference to all the counties.
I will take that under advisement.
It's beautiful. It's stunning.
I think I have a good one at Mount Lemon I'll use next time.
There you are, Commissioner Lerner.
Hi, sorry about that. I was having trouble. I logged in, logged out. I was having some problems. Sorry.
No, we're relieved whenever there's the possibility of the problem. We're relieved, to see the tile pop up.
So Erica, you and Shereen have turned me into a Suns fan, so now I'm living and dying by the Suns. Yeah.
Well, after yesterday, it might not be the best one. So
no, it was looking good, and last night was not a good night. So hopefully, better game next time.
I have confidence because they're built well. They're coached well. They're built well.
It sounds like the same to me.
We'll see. I don't know.
Yes.
Okay, we're early. I actually did. I think our entire team is on and ready to go. Am I correct?
Yes, looks that way. Good morning.
Okay. Good morning, Vice Chair Watchman.
good morning.
Oh, it's 8 o'clock. Good morning, everyone. We have our entire team. Welcome, public. We can dive right in. Agenda item 1, call to order and roll call. 1A, call for quorum. It is 8 a.m. on Tuesday, June 29th, 2021. I call this meeting of the Independent Redistricting Commission to order. For the record, the Executive Assistant, Valerie Newman, will be taking roll. When your name is called, please indicate you are present. If you're unable to respond verbally, we ask that you please type your name. Val.
Vice Chair Watchman.
Present.
Commissioner Lerner.
Present.
Commissioner Meal.
Present.
Commissioner York. Commissioner York, can you hear us?
Yes, present.
Thank you. Chairperson Newberg.
Present.
And for the record, we also have in attendance Executive Director Brian Schmidt, Public Information Officer Michelle Crank, Brett Johnson and Eric Spencer from Snell and Wilmer, Roy Herrera and Jillian Andrews from Ballard Spar, Mark Flahan from Timmins, and Doug Johnson from NDC Research, and Angela Miller, our transcriptionist. Thank you. Back to you.
Thank you, and please note for the minutes that a quorum is present. Agenda item 1B, call for notice. Val, was the notice and agenda for the commission meeting properly posted 48 hours in advance of today's meeting?
Yes, it was, Chairwoman Newberg.
Thank you very much to you and to the team. Agenda item number 2, approval of minutes from June 22nd, 2021. Agenda item 2A, there was only general session minutes. There was a minor typo that Val, corrected prior to the meeting. Aside from that, is there any discussion? If not, I'll open it up for a motion to approve the general session minutes from June 22nd of 2021.
Madam Chair, Vice Chair Watchman moves to approve the June 22nd meeting
Do I-
minutes.
Thank you. Do I have a second?
Commissioner Meal seconds.
Commissioner York.
Commissioner Meal seconded. Thank you very much. For the record, any further discussion? A quick vote. Vice Chair Watchman,
Aye.
Commissioner Meal,
Aye.
Commissioner Lerner,
Aye.
Commissioner York.
Aye.
Commissioner Newberg is an aye. The minutes for the general session are approved for June 22nd of 2021. Thank you very much again, Val. We'll move to agenda item number 3, opportunity for public comments. Public comment will open for a minimum of 30 minutes and remain open until the adjournment of the meeting. Comments will only be accepted electronically in writing on the link provided in the notice and agenda for this public meeting and will be limited to 3,000 characters. Please note, members of the commission may not discuss items that are not specifically identified on the agenda. Therefore, pursuant to ARS 38-431.01H, action taken as a result of public comment will be limited to directing staff to study the matter, responding to any criticism, or scheduling the matter for further consideration and decision at a later date. We move to agenda item number 4, discussion on public comments received prior to today's meeting. I open it up to my colleagues.
This is Commissioner Lerner. I just want to again say thank you for people to give us comments. We got a number of comments about the public meetings that I noticed, and we're in agreement that we want good, orderly meetings, civil meetings. We're going to be hopeful that that occurs, but just want to acknowledge that we all would like to have those kinds of meetings because those are for us to hear from you, from the public as part of that. So I just wanted to acknowledge that, and we'll be continuing to talk about how our public hearings are organized as we go through that. So I just wanted to say thank you for that.
Any other thoughts? I actually have quite a few thoughts, and thank you, Commissioner Lerner, and you do get a good shout out in the comments. Well deserved for your diligence and your contributions, as well as, to be honest, all of my commissioners. I'm deeply appreciative for the attentiveness to homework and detail. I know there's concern in the public about computer-generated comments, and along with that, groups and organizations that are large and are capable of submitting kind of templates or just form letters. And we would like to reassure the public that we're able to distinguish, information that we receive. That information is important. If an organization has thousands of members and they take time to submit information, that's relevant. But, if it's form versus the time that individuals take, we will work with our entire team. We have an experienced team to learn how to translate all of this into the most relevant data, because that's really what it's about. The information tour is to learn and to understand the data as factually accurate as we can, and to translate that into representation in government. So we hear you, and we're learning and studying this very issue. There was also a question about how to tailor public comments to our process. I thought that was an important question, and I'd like to reiterate some of the conversation that we've already had. When you are expressing your opinions, and this is relevant to submission through online and also our upcoming meetings, we will do our best with our stock presentation to elicit this feedback, but we want to understand your community of interest. We want to understand the subgroups of your communities of interest. We want to understand, does that fit in or tap into any geographic realities? We want to understand the history of your community in terms of your needs, what's not being met, and what you feel, needs to be met. And the comments that are submitted and communicated in a respectful, positive tone, to be honest, are a little bit more effective. Security. Yeah, absolutely. We will be requesting guidance and support from DPS in order to provide the best possible security. This is the heart and soul of democracy, and we take this issue very seriously. The timeline. I know it's frustrating. We're going to hear about it later today. Please understand, we're integrating many different aspects of our team that have different angles on the timeline. And rather than prematurely giving information that, to be honest, isn't meaningful, we ask for your patience such that it's real information and you're going to be constructive. Closed captioning for hearing impaired. I thought that was a great comment, not just for that one specific issue, but making sure that on our speaking, our listening tour, that we're ensuring that all communities are able to communicate with us. So I appreciate that reminder of our responsibility to provide means of communication. A comment again about our legal counsel and potential conflict of interest. I want to remind the public that it was May 11th at a public meeting that we issued a statement that both legal counsels approved of. And just to highlight the most important points, IRC's legal counsel will not be advising any candidate, political party, or political committee in regard to the Arizona redistricting process. It's understandable that the IRC's legal counsel will continue to advise clients in regard to other unrelated election law matters. There's no reason to believe that the IRC's legal counsel will not honor their ethical duties to maintain the confidentiality of IRC information. And along those lines, I would like to just express that I have only seen two law firms and their counsel, the individuals, working with a deep level of cooperation, a remarkable level of accessibility, and I have no doubt that there's a commitment to our commission and our state. First and foremost, there's a tremendous amount of eyes that are on this process, including an active commission. And so up to now, I believe the commissioners are quite satisfied and have full access to our counsel. And so I'm confident in the process. My final comment, and I know I'm sharing a lot today, there's a lot of talk about asking the commission to do the best that we can to reach out to the entire state and make these listening tours meaningful and to understand the information that we're getting. We hear you and we are doing our best. I'd like to say, you're all partners on this. You're on the ground all throughout the state. You have tentacles. When we release, when the press releases something to say there's a meeting, we ask you, please do your best to send it to, fire departments, police departments, school districts, the heart and soul of the Arizona public. So we hear you, but please also be our partner on that. Aside from that, any other further, comments or conversation from my colleagues? Okay, thank you. With that, we'll move to agenda item number 5, update from our mapping team, Timmons, NDC. Please take it away.
Well, thank you, Madam Chairperson. The biggest thing that we've been working on this week, you guys have had a lot of conversations already about the listening tour. So we've been, making a lot of preparations on our side to, help support you guys going forward on the listening tour and collecting the community of interest data. We're going to continue working on that this week and going forward. The other couple things that we have for you is we have been working on the social economic report, and the data is almost wrapped up, so we can start to work on getting that displayed to provide that to you. You asked about a tentative calendar a little bit. So, in July, the tentative listening tour could be coming, and we're going to be supporting you guys on that and doing a lot of preparation for that coming up. We'll be cataloging community interest data. In August, the redistricting software should be ready to go and be installed. And then we get the census data on the 16th of August. So that'll be exciting for everybody here. And then after that, we'll be working in getting the census data put into the system and ready to go in August for start on that data in September. So that's sort of the preview of the next couple months for us. Lot of stuff going on, a lot of moving parts. But we're here with you to support you guys going forward. With that said, I'll open up. Are there any questions from your team?
This is Commissioner Meal. I have a question. So the first step after we get the census data, as I understand it, is to produce grid maps. And I also gathered that there's a variety of way of doing a grid map. So what decisions or what directions do we as a commission need to make prior to August 16th so that you're ready to go immediately producing the initial grid maps?
Doug, you want to answer that one?
Sure. I think you put it very well. There are a number of different approaches, flipping coin for choosing a starting point and flipping coins for deciding which way to go. There's also some new kind of computer auto-generated options for you. So one of the steps in this process is we will need to present you those options and let you pick which one you want to follow. So that'll be something we'll be coming back to you with. I don't know when we'll be doing that, but it's certainly something we need to get on your schedule.
I would encourage that to occur before August 16th so that those decisions can be made and settled in so that we can really get going quickly.
I agree 100%, definitely.
This is Commissioner Lerner. Last time we'd asked you for a little bit more of a revised calendar, and I know you just gave us a very general July, August kind of thing, and I was hoping for something a little bit more detailed than that from you, which would include, and now what Commissioner Meal said, maybe a date that says by August 1st we will have presented these options so we can select it. Personally, I'd like to have some understanding of more specifically what you're doing over these next couple of months. We also had asked about when training would be available and hoped for that you could give us a date on that. Whatever the date works, I'm not telling you which date, just if it's July 15th, if it's July 30th, whatever that is. And when the public, because I think the public would like some time to also get up to speed with the technology. So if you could give us, again, I know we had talked about this last time, if you could give us some dates that you have, your target dates, whatever works for you, but if you could give us those target dates, when do you hope to have the socioeconomic, report done? When do you hope to have the availability of training for us, training for the public available? When would you want to have that presentation on the options that Commissioner Meal just spoke about? Those are things that would be helpful for us to be planning ahead, as at least for me to be helpful on that. And then also, I know we had talked last time about you would provide us some input on the listening tour. And I don't know if you have anything prepared for that, or maybe you've shared that with Director Schmidt and given some specifics on that. But we thought that by this week you might have something specific that you would be giving us. So just some questions on those kinds of things.
Sure. On the listening tour, we have been working with Director Schmidt on that behind the scenes, and we have sent him some stuff on that. On your question about training, it will probably be the right beginning of August. I don't have an exact date because we're still spinning up the system, so I didn't want to give you an exact date just yet on that. But I know that's of utmost important for the commission, and as soon as I have that date, I will be able to share it with you.
Yeah. And as to Doug, I would just add to that, in training on the software is important, but also training and introduction to all the different concepts you're going to run into, right, through this process.
Right.
What are communities of interest? How do you identify them? What is competitiveness, and how can you measure it? All those in-depth look at the Voting Rights Act, all those things we need to get scheduled and get a good presentation for you. We're working to get all those things put together.
And Mark, let me, Commissioner Lerner, I apologize. This is directly relevant to your line of question. Mark, you mentioned that you're working with Director Schmidt behind the scenes on some of these things. Given that we're a very public body, do you? Yes, I personally have seen it, but the public hasn't. So do you mind just maybe sharing a little bit more detail in reference to Commissioner Lerner's question? I know you've been working a lot about the stock presentation and about how to elicit the right kind of feedback at public meetings. If you could catch the public and the commission up to date about how much you have been doing and what you've been doing, I think that would be helpful.
Sure. So, for the listening tour specifically, we have been, creating, what agenda could look like for the listening tour, the different feedback mechanisms that we should be soliciting. How do we actually solicit feedback from the public for the listening tour, so we can develop the community of interest report going forward. Probably the next step will be talking about, the catalogization of data. How do we catalog that? So we've been providing a bunch of that. We've been providing data about competitiveness going forward. So there has been a lot of stuff that we've been working on behind the scenes. Does that help answer your question?
Well, from my perspective, because I haven't seen any of that, that's why I'm asking the question. Because I appreciate the fact that you're doing that behind the scenes, but because I hadn't seen that, I was unaware, and then the public is also going to be unaware as part of that. So I don't know if there's a way for us to start having input, even if it's behind the scenes. I would appreciate seeing what you're putting together, so I could potentially provide some comments, and other commissioners as well, as part of that, so that when you're ready to present, maybe you don't have a million comments coming at you. But that's why I'm asking these questions, because your update is similar to last week, but I know last week we had asked for a little bit more specificity for this week, and just to clarify why I'm asking these questions.
And to add to Commissioner Lerner's comments, it's going to get pretty intense after August 16th. And as commissioners and the public getting a little bit better idea of a timeline on when we will have grid maps, when we think we're going to have the preliminary maps, because then we have another listening tour that's going to be a couple of weeks like this, the initial one. that will be very time intensive, and it would be great for all of us to have a little better idea of when these things will occur as we schedule the rest of our lives. So, so getting a little bit better tentative schedule going forward would be very helpful.
Okay, I will get something more that I can present at next Tuesday. Graphical.
Thank you.
Thank you. Yeah, from my perspective, as much as we can be informed of things up front so that we have time to process, rather than having to make a decision the day of, it would be helpful. Thank you.
And a lingering question I have that I would love the commission to be involved with. You know, you raised, how do we catalog community of interest data? Will we be, you know, I don't know. I don't understand that process.
Doug, you want to take that one?
Excuse me? I'm not saying that you have to answer it like literally right now. What I'm getting at is I think the commission would like to be involved in that. So we need to understand it and then have sufficient time to process it.
Yeah, just one thought listening to this discussion too, my dad, is I think one of the things we need to do is work out topics we're going to present and discuss each meeting. And you know, obviously your questions today will be a big part of that, just because you know, it's really hard for us to answer a lot of these questions on the fly. So it would be, I think if we can work out a schedule, taking what you shared with us today, work with Director Schmidt on what should be discussed at each meeting, we can come much more prepared and ready to know what you want us to address, and of course what we think you need to be aware of at a given point, in addition to the things that you ask us about outright. That we can work on getting that prepared and come to you.
We'd appreciate that. You actually, we don't have a meeting next week, so there's a 2-week, you know, window to do, I think, a lot of the homework and just the work behind, you know, these questions. So I think when we reconvene, you know, I'm hoping that we're going to have a lot of answers and we'll really be on the same page.
And this is Commissioner Lerner again. Just as a reminder, you had said that you would take that your schedule and calendar that was quite lengthy and try to condense that, and you were going to try to get that to us this week. But if you can include that as well, you were going to modify it, of course, accordingly, because we started later than what you had anticipated, and just make the adjustments that you need to make. It would be helpful for us to see that as well, and you can always email that to us if in addition or at any point. But I think that would be helpful for us overall, and it would be helpful for you as you plan ahead.
And if I can just add to that, Commissioner Lerner, just completely agree. And for those members of the public watching, anything that we email to you, of course, will get published to the website as well, so the public will see it at the same time.
Okay, thank you very much. Is there any other further questions or thoughts from my colleagues? Okay, thank you very much, Mark, Doug, your entire team. We look forward to, you know, the updates and moving forward. We'll move to agenda item number 6, Executive Director's Report and discussion thereof. And I turn it over to Director Schmidt.
Thank you, Chairwoman. So I have a few updates for you today. We are fully moved into our new office space. Our address is 1110 West Washington, and we're in Suite 127 now. And all that information has been updated on the website. The budget passed both the House and the Senate, and it's been transmitted to the governor. The budget includes $7.9 million in non-lapsing funds and an increase in our FTE positions. We're just about to end the fiscal year. So I will get you a year-end report in the next couple of weeks as soon as it's ready. In regards to the IT migration, we have one proposal. I'm waiting for one more to come in. As soon as I get those, I will present them to you. I know everyone is anxious to move forward on this project, but we need it to be the right fit and make sure it's done right. And then the last item I have for you all today is the deputy director recommendation. And I just, before I say it publicly, I want to see if any of the commissioners wanted to go into executive session to discuss. If not, I'm content moving forward.
Please move forward.
All right, thank you. For the deputy director / public records manager, I'm going to recommend hiring Lori Van Haren. Lori is currently an assistant city prosecutor at the City of Phoenix Prosecutor's Office. She's responsible for and has helped develop many of the successful programs for the city's Veterans Court. Prior to that, she served as chief of staff for Councilwoman Mendoza. She not only has a tremendous amount of knowledge on the legal side and with public records, but also with community outreach and engagement. She also speaks Spanish and will be a great addition to the team.
I'd like to just acknowledge and thank Director Schmidt for the thorough process. We received really, you know, a number of incredibly impressive applications. I'm thrilled that so many, you know, really skilled, talented people in our community are interested in the process. And I appreciate, again, my fellow commissioners who took the time to review the applications, provide feedback, and personally, I'm really, really excited about potentially welcoming a new member to our team. Any other conversation? All
This is
right.
Commissioner York. Yeah, this is Commissioner York. I read Brian Schmidt. I read your review. I'm excited to offer Gabrielle a job. Do we need to motion that, or is it
Yes,
Brian's responsibility?
that's what we've done in the past.
Okay.
So we need a motion to approve the potential hire of this deputy director, correct?
Yes.
Correct.
Okay. I'll entertain a motion.
I thought Commissioner York was making that motion.
Oh, I'm, you know what, the
I don't know
audio,
if you did or not. Doug, you're a little choppy. So, I mean,
Yeah, I'm on a crazy Wi-Fi connection. I'm not in my office. I motion that we go ahead and hire the deputy director that Brian has recommended,
Okay.
Gabrielle.
and
I'll second.
whoever.
any further conversation? Vice Chair Watchman.
Aye.
Okay, Commissioner Meal,
Aye.
Commissioner Lerner,
Aye.
Commissioner York,
Aye.
Commissioner Newberg is an aye, and with that, a 5-0 vote, and we welcome our new deputy director. Brian, is it maybe 2 weeks, or
Yes.
what's the estimate? Okay.
Hopefully July 13th-ish. So
Okay.
as
Wonderful.
soon as possible.
We look forward to it. Thank you for your diligence in vetting all of these terrific candidates. If there's no, we're done with that item. We can now move to agenda item number 7, discussion and possible action on proposed revised travel schedule. Director Schmidt.
Thank you, Madam Chair. So the schedule that we presented last week, I'm pulling it up just so everyone can follow along. It's still the same schedule. We are working out all of the details. I don't want to post any of the venues before we have them 100% nailed down. But the public, if they would like to go to irc.az.gov and sign up for the newsletter, we're hoping to have it completely finalized within the next week. And if you sign up for the newsletter, we will send out the dates with all the locations as soon as they're finalized. And for the commissioners, Valerie put together a kind of a travel guide for you all. And we will get that to you along with some forms just for reimbursements and all that kind of stuff. So we're working through all those kind of details right now, but can't wait to get it finalized and out there.
Brian, this is Commissioner Lerner, a quick question. Is there a way to, in addition to, in case people don't see the newsletter or don't want to receive a newsletter, I know a lot of folks don't like to get extra materials. Will that also, is there a way to post at least the dates at this point, knowing that you don't have all the locations on the website, just to list them? And they may be already, and I don't realize that.
Yeah, and I believe they are posted. I will double check the specific location. I'll let you know, but they should be up there.
Okay, thank you.
You're welcome.
I saw Val gave a thumbs up, and it's like a save the date. I think it's great.
It's in the newsroom.
And do we have times, or will the times vary on some of these depending on the locations?
We're hoping that the weekday ones start at 5 o'clock. The weekend ones will start at 9 a.m. or 10 a.m. So we're going to try and be as consistent as possible, working with the different venues.
And Director Schmidt, I wasn't sure how the satellites are going to work. Can you share with us the vision of the main location satellites and how that fits in to the commissioners and the public?
Sure. So we wanted to make it as accessible as possible if people did want to attend a meeting in person. So that's why we proposed the satellite locations where people don't have to drive an hour and a half to make it to the main location. They could go to, I know, one of the smaller ones, and then we'll integrate them into the meeting as a whole. So we're working on a technology fix where they would be able to participate from their community at the main meeting with everyone else.
But they will be participating virtually. We're not dividing our broader team to have representation there. Is that what I'm understanding?
We'll have team members at each of the satellite locations.
Okay. And commissioners, is that something? Will we be at those of us who are traveling physically will be at the main location, or is that something that we need to discuss?
It will be up to all of you. If one of you would like to go to one of the satellite locations, you could do that, or be at the main location. It's your preference.
Okay, thank you. And the community's needs.
Absolutely.
So thank you.
As a question is, are these going to all be recorded then as well?
Yes.
Okay.
And we're planning to have them live as well.
Thank you. And thank you to the public for, we've had quite a few great offers with venues and great ideas, and the commissioners who have been involved. It's truly, this is a team effort. Any other conversation, feedback, thoughts about item number 7, our travel?
This is Commissioner Lerner. If you're having, if you're not sure of some of the meeting locations, if you want to send out a list of where you might be having some trouble finding a place to the commissioners,
sure.
It might be that we know some folks in places that can assist you. So if there's still some places where you're uncertain on a location, if you let us know, we might know some folks who can provide assistance.
Absolutely. Thank you.
Okay. Thank you, everyone. With that, we will move to agenda item number 8, discussion and possible action on stock IRC presentation for public use. Director Schmidt, you want to give us an update on just our mapping team alluded to some back and forth. I know there's been a lot of hands on the product, which is positive in a positive way.
Yes, so the mapping consultants went through the presentation, added pieces they thought would be important. We got that back to legal. Legal ran through it, and I just received the most revised version. So I will send that all to you all today. So you can take a look at it and let us know if there's anything else you would like to add or edit. But we should have that fully ready to go at our next meeting, so the public can have it and use it if they would like.
Terrific, thank you. Any questions? With that, we will move to agenda item number 9, discussion and possible action on census data, census delays, and ways to mitigate its disruption. We have A, B, and C regarding 9A, status of speakers regarding the pros and cons of differential privacy. We have been discussing amongst ourselves and the public the need for us to analyze this differential privacy issue. We have, thank you to legal counsel. There's a recommendation and we've secured some, expert speakers. One on the pro side regarding backing the Census Bureau, another on the con side challenging the Census Bureau. They are slated to speak to our community on July 13th at that public meeting. And we look forward to being further educated on that challenge. We have, I'm happy to entertain questions or comments on that before we move to B and C, if there are any. Okay, regarding B and C, again, thank you to our legal counsel. We have 2 presentations, item B on the Voting Rights Act, and then item C, the Arizona Constitutional Redistricting Criteria Requirements. Our plan is, and again, this is in deference to a significant public comment, we will have counsel do these presentations in public session. We're going to take each item separately. So we will first address B, then C. I'm going to ask the commissioners, please write down and generate your personal questions about the presentation as it relates to our work, as it relates to applying these things to Arizona, so that we can use the ability to go into executive session to get legal counsel on specific questions that we might have in our job. So just for the sake of organization, we'll start in public session on agenda item 9B. I'm going to recommend that after the public presentation, while commissioners are jotting down their personal notes, unless there's something just obviously, I don't understand that word or that slide, that the entire public would have the same question. And then after that presentation on agenda item number 9B, we move into executive session. And then we'll do the same with agenda item 9C. And if everybody is okay with that general suggestion and guide, I will turn it over to our counsel.
Thank you, Madam Chair. One additional update before item B, though, because this was a question that we received the last couple of weeks, is that there has not been any update on the Alabama litigation on the differential privacy. So just provide that information. So we're going to turn to the Voting Rights Act presentation first. So I'm going to try to share my screen here. You could see. a little ahead on this presentation, so let me go back to the beginning here. As I'm scrolling, I think the purpose of today's presentation is to provide an overview of the Voting Rights Act, the requirements under the Voting Rights Act, and then that'll be followed by the requirements under the Arizona Constitution. Of course, as Madam Chair indicated, we're happy to answer questions on that as we go along on the slides, or of course, as Madam Chair indicated, if there are questions about the application of the Voting Rights Act, we can answer them in the end. To give you a little bit of agenda setting today, I'm going to start with an overview, a historical overview of the Voting Rights Act, basically providing information about why the Voting Rights Act was initially enacted. And then we're going to go into Section 5 of the Voting Rights Act, which has seen a significant amount of change since the last redistricting commission as a result of the Shelby County decision. But nevertheless has some applicability still to redistricting. So I'm going to explain that. And then after that, we'll get into Section 2 of the Voting Rights Act, which is the most operative and important provision of the VRA at this point in its application to redistricting. And then we'll end with the conversation about racial gerrymandering, which is a distinct claim under the 14th Amendment, but nevertheless shares a lot of principles with the Voting Rights Act, and discuss that. So let's just start with the historical overview of the Voting Rights Act. So the VRA was initially enacted in 1965 to sort of set the context of this. After Reconstruction, a number of states, particularly in the old Confederacy in the South, enacted different measures that made it difficult for minorities to vote. A lot of these measures are things that you're well aware of, things like poll taxes, property requirements, property ownership requirements, literacy tests. And as a result, eventually, in the late 50s, Congress passed a series of civil rights laws to try to protect minorities' right to vote. But what we saw is that many of these laws ultimately proved ineffective because we would be, and I explained this in a later slide, we'd be in a situation where because under those previous pieces of legislation, the onus would be on someone bringing a lawsuit to get a particular procedure or provision under state law invalidated. That essentially what would happen is people would bring a lawsuit, and then even if that particular provision would be found to be unconstitutional, or I should say illegal under federal law, then the states would just follow that up with enacting a new piece of legislation. And so what eventually the Supreme Court refers to as a whack-a-mole became part of the problem. And so eventually Congress decided that a more comprehensive and expansive Voting Rights Act would be necessary. And during the height of the civil rights movement in the 60s, particularly after the March on Selma in March of 1965, we finally saw an increased support from the White House for a more comprehensive Voting Rights Act. And so therefore, after that, in August of 1965, we saw President Johnson sign the VRA into law. Over time, the VRA has been amended. It's been amended 5 different times. The most recent amendment came in 2006, but before that, it was amended in 1970, 1975, 82, and 92. And as time has gone on, these amendments have expanded the protections under the VRA. So initially, a lot of the lawsuits and the various challenges under the VRA were primarily challenges that directly were trying to invalidate things like poll taxes, things that would directly disenfranchise minority voters. But eventually, the expansion of the VRA included considerations on whether different voting procedures would actually dilute minority voting. And vote dilution in particular is a huge issue when it comes to redistricting. Perhaps the sort of most common objection to redistricting plans that you'll see under Section 2, which I'll explain a little bit later. But there has been, like I said, amendments of the VRA that has expanded its protections over time. Let me go to the next slide here. So I'm first going to talk about Section 5 of the VRA, which is known as the pre-clearance provision. As I have here in the slide that it's not dead but dormant. What I'm referring to, and we'll explain in a few slides, is that as a result of the Shelby County decision, which invalidated the formula under Section 4, the coverage formula under Section 4, there are no jurisdictions that are now covered by Section 5. So we're in a situation where Section 5 is still a live section. In other words, that has not been found unconstitutional by the Supreme Court. But because the coverage formula under Section 4 has, Section 5 really has no application at this point. But it's still nonetheless important. One, because theoretically, Congress could decide to enact a new coverage formula. It's unlikely for political reasons. And as I get to a little bit later, the Supreme Court has indicated that even Section 5 may be unconstitutional. Of course, it hasn't found that yet, but it's possible. But that is, theoretically a possibility. We could see a new coverage formula. But more importantly, some of the principles, particularly retrogression under Section 5, are still important considerations under Section 2, and I'll explain that in a moment. But first, let's just talk about Section 5 in general. I referred to it earlier as the pre-clearance provision because essentially what it would require is for covered jurisdictions to get pre-clearance from the federal government, so either through district court in the District of Columbia or the Department of Justice. Of course, this is at the point that the VRA was enacted. Voting procedures and voting laws is primarily reserved to the states. So the power to enact those laws are primarily preserved to the states. So adding this pre-clearance provision where the states would have to go and get pre-clearance from the federal government was and has been referred to in case law as strong medicine, because it's a pretty expansive exercise of federal power. It was. And as I referred to before, and I say in this slide, it was designed to end a game of whack-a-mole between the federal courts and states that were determined to preserve white electoral dominance through, again, various things like poll taxes and other kinds of voting procedures. And so, again, under the late 1950s Civil Rights Acts, it was a case-by-case approach where you'd have to go through litigation to try to, again, get particular provisions to be held to be unlawful. Because of pre-clearance, the onus will be put on local jurisdictions or covered jurisdictions, I should say, to go to the federal government and get approval, essentially, of those particular provisions before they actually go into effect. And again, that idea here was to bring an end to the discriminatory voting practices of the Jim Crow era after Reconstruction. Going now to sort of what actually Section 5 says and what it required, what will still requires technically, is it requires certain states and local jurisdictions, again, these are referred to as covered jurisdictions, to seek prior approval or pre-clearance from the federal government. And this is important to enact or seek to administer any voting qualification or prerequisite to voting or standard practice or procedure with respect to voting. Redistricting falls within this definition as a prerequisite to voting or a standard practice or procedure with respect to voting. So in other words, redistricting plans have traditionally had to go through pre-clearance, again, when we had a working coverage formula and had covered jurisdictions. So as a result, the state of Arizona in 2000 and 2010 did go through pre-clearance and has historically gone through pre-clearance. So that was a feature of the last a couple of redistricting commissions and redistricting cycles. And again, because of Shelby County, we don't have that requirement anymore. So that is a major difference. And again, we can talk about that in more detail. But as I mentioned, covered jurisdictions, in other words, jurisdictions that would have to get the pre-clearance, were determined by a coverage formula in Section 4. So what was that Section 4 coverage formula that was eventually found unconstitutional by the U.S. Supreme Court? Well, originally it began by looking at data as of the 1964 general election, and in particular, it looked at two different things. First, there was a question of whether a particular state or local jurisdiction employed a discriminatory test or device. If it did do that, in other words, it had literacy tests or good character requirements or property ownership requirements for voting, that would fall within this discriminatory test or device, and therefore you would have met the first requirement of the coverage formula. The second is really a question of voter participation. So as of the 1964 general election, the question is whether in that state or local jurisdiction, fewer than 50% of voting age residents were registered to vote or voted in that particular election. So that was the original coverage formula under Section 4. But eventually, and as it was applied originally, it really applied to most of the states of the Jim Crow South, or in other words, ex-Confederacy states. But eventually, the pre-clearance requirement was expanded to not just look at the 1964 general election, but to also look at the 1968 general election and the 1972 general election. And it was that expansion to look at three different, or to possibly look at three different general elections, that then expanded that coverage formula to the state of Arizona. So when that expansion occurred to include those three three general elections, states like Texas, Alaska, and Arizona were then included in the coverage formula. And just, for your awareness, what the discriminatory test or device was in the state of Arizona that was found to fall within and fulfill the first requirement of the coverage formula was that we had a policy of providing voting materials only in English, and we used a literacy test for voting, which that procedure was discontinued up until 1975. So again, as of the 64, 68, and 72 elections, we had this discriminatory tester device, in addition to meeting the voting participation requirement. So that's why Arizona became part of the covered jurisdiction under the existing Section 4 coverage formula. So let's go now into what exactly Section 5 prohibits covered jurisdictions from doing. So if you're a covered jurisdiction, or were under the coverage formula at the time, you were prohibited from implementing any electoral change that has the purpose or will have the effect of diminishing the ability of any citizens of the United States on account of race or color to vote. And that importantly included both electoral changes, including redistricting plans that had a discriminatory purpose or an innocent purpose, but had a discriminatory effect. And this both purpose and discriminatory effect is a feature, again, of the VRA being more expansive over time. Now, discriminatory purpose is an interesting feature. It's a bit unclear, and you'll find in some of these different tests that sometimes the factors and the standards are not entirely clear. In other words, courts have sort of struggled with determining what something is, whether something is or not, or is not a violation. But in general, for discriminatory purpose, the Department of Justice in 2011 adopted a series of factors actually coming from a discriminatory housing case as factors that courts should look to determine whether there's discriminatory purpose. However, in 2013, because of the Shelby County decision, all of that essentially became moot because Section 4 no longer provides for any covered jurisdiction. So we actually have no sort of sense really of what those adopted factors for discriminatory purpose actually mean yet, because again, this section has been determined to be moot. On discriminatory effect, as I have here, that is typically determined by the principle of non-retrogression. So non-retrogression is a very important term under Section 5. It's probably the most important term under Section 5. And what we're getting at here, and I have this quote from the Beer case, is whether the ability of minority groups to participate in the political process and to elect their choices of office is diminished by changes affecting voting. So the idea, again, is it focuses on whether, in adopting this or applying this to redistricting, it focuses on whether a redistricting plan expands or at least preserves the number of districts in which minority voters are able to elect the candidates of their choice. So that's essentially what you're looking at, and I'll have a comparison chart here on the next slide in a moment, which explains this further. But you're looking at non-retrogression, and if there is some sort of retrogression, there could be a violation of Section 5. Now, again, as I mentioned before, Section 5 is currently moot because there's no covered jurisdictions, because there's no coverage formula, but it's still potentially an important consideration under Section 2 of the Voting Rights Act, which we'll explain when we get to that section. Now, I've kind of beat a dead horse here a bit on Shelby County, but just to talk about that for a moment, as I mentioned, Congress continuously amended and reauthorized the VRA, but it retained over that time the Section 4 coverage formula, which was, again, based on the 1964 through 1972 elections, so the 3 presidential election cycles. But this is an important fact because in the Shelby County decision, the Supreme Court criticized the use of those particular election cycles for the coverage formula. And in particular, it said that it could not justify the application of the formula based on decades-old data and eradicated practices. So I think what was partially informing the court there was that the data that we were looking at, 64 to 72, was so long ago. And so therefore, the coverage formula was unconstitutional. Now, again, as I mentioned, Section 5 was not declared unconstitutional, but without any kind of pre-clearance formula, there is no jurisdiction that is covered or subject to its requirements, and therefore it is moot. And also, as I mentioned, Congress could theoretically create a new pre-clearance formula. Again, that's probably unlikely under the current political circumstances, but it is possible. But even if they did that, that would be subject to a legal challenge, probably a legal challenge that would directly, ask the court whether Section 5 itself was unconstitutional. So that's Section 5. We're going to turn now to Section 2, which, as I have here, is the core of the modern Voting Rights Act. It is the operative provision. It is the provision under which you will see any sort of VRA challenge. And certainly when we talk about vote dilution under Section 2, those are the kinds of challenges that you see quite often in redistricting. As I said, post-Shelby County, Section 2 is the major remainder of the VRA. going, and I have two quotes here directly from Section 2 of the VRA. First, it prohibits any voting qualification or prerequisite to voting or standard practice or procedure which results in a denial or abridgment of the right of any citizen of the United States to vote on account of race or color. So you'll notice in this particular definition, it refers to both denial or abridgment. And that sort of corresponds to the two types of cases that you see under Section 2. The first are vote denial claims, and the second are vote dilution claims. When it comes to redistricting, vote dilution claims, again, are the primary form of a Section 2 objection or a Section 2 lawsuit. But you also see vote denial claims quite often in other contexts. And the Brenovich case is a good example of that, which I'll get to in a second on the next slide. But again, in Section 2, it goes on to define when denial or abridgment actually occurs. And as I say here, it is shown that it occurs when it is shown that the political processes leading to the nomination or election in a state or political subdivision are not equally open to participation by members of a class of citizens, in that its members have less opportunity than other members of the electorate to participate in the political process and elect representatives of their choice. So that last phrase, representatives of their choice, as you'll see in the actual standard under jingles, is pretty important language. Now, again, there are some similarities between Section 2 and Section 5 in certain respects, but they diverge from each other quite a bit. And I think I may have said this before to the Commission a long time ago, this quote that I have at the top that refers to Section 2 as the legal sword that enables minority voters to improve their electoral position, while Section 5 is the shield that prevents minority voters' position from worsening. That's taken from probably the sort of most central election law textbook, legal textbook. But I have here, a chart that sort of talks about the differences between the two sections. I start both with the standard, as we've talked about already in Section 5. The standard there really goes down to retrogression. In other words, is the challenge procedure resulting in a minority group losing ground? Section 2 is different. The question under Section 2 really is whether a group's members have less opportunity than other members of the electorate to participate in the political process and elect representatives of their choice. So again, two different standards have some similarities to each other, but they are different. Second, when we're talking about the scope of the application, as I mentioned before, Section 5 applies only to covered jurisdictions, of which we have none currently, whereas Section 2 applies to every voting jurisdiction, no matter what coverage formula. There is no coverage formula. So Arizona, for example, Section 2 applies to Arizona's voting procedures. And then a crucial point here, I think, is this last row, which is, how do they differ when it comes to the initiation of proceedings? As mentioned before the Voting Rights Act, one of the issues with the prior civil rights lawsuits is that it required plaintiffs to bring challenges, and sort of the result of that litigation made it difficult in this sort of whack-a-mole situation to stop the states from doing various things locally. The idea with Section 5 is that would put the onus, pre-clearance would put the onus on local governments or state governments to go to the federal government and get permission for particular voting procedures. But of course, that's Section 5. Under Section 2, which is again the operative provision now, plaintiffs are required to bring challenges. So instead, the onus is actually, or the burden rests on the plaintiffs to bring challenges under Section 2 of a violation by a particular voting procedure, which again includes redistricting. So as I mentioned before, under Section 2, you see two different types of claims primarily. The first are vote denial claims. This is when the challenger is alleging that a voting procedure has resulted in not being able to exercise their right to vote at all. I mentioned the Brenovich case. Those of us who are election nerds, mostly Eric, was up early this morning to see whether the Supreme Court would issue a decision in the Brenovich case, since we're nearing the end of the term. We didn't get a decision today on that case. It looks like it's going to be later this week that we're actually going to see it. But we have this in here because although the vote denial cases are distinct from vote dilution cases, which again, vote dilution cases are what you typically see under redistricting, and also vote denial cases have a different standard than vote dilution cases, it nevertheless can be an important case because we'll see this Supreme Court, which has changed quite a bit in recent years, it'll be their first decision under what Section 2 requires. And so I think we're all sort of waiting on pins and needles to see what that is. My suspicion, and this is also what I think some elections experts are saying, is that the decision is likely to be a bit messy. So we may not see sort of a very clear precedent that comes from it, but nevertheless, it is important for our analysis to get an indication of where the Supreme Court is leaning and how it's viewing Section 2. But again, vote dilution cases is what we see in redistricting. So what are those kinds of challenges? It's a challenge that alleges that a voting procedure has resulted in having less opportunity to exercise political power equal to that of a member of a different group. And so essentially a voting procedure like redistricting, that allegation would be that the redistricting has resulted in having less of an opportunity to exercise political power equal to that of a different group. Now, when I sort of quote here from the Jingles case, and I'll get into the Jingles factors, which is the test under Section 2 for vote dilution. And by the way, it is pronounced Jingles. We actually had to look this up because I didn't know if it was Jingles or Jingles, but it's Jingles. The quote here I think is important. When the dispersal of racial minorities into districts in which they constitute an ineffective minority of voters, or from the concentration of racial minorities into districts where they constitute an excessive majority, that is when dilution can occur. And this refers to the two different types of dilution that you typically see, which is packing and cracking, or cracking. And I'll get into what those are. But this quote, I think, describes it pretty well on when you can see vote dilution occur. So how do vote dilution claims arise? They most often arise when minority voting power is diluted by the creation of insufficient majority-minority districts. And so I have here the definition of a majority-minority district, which is that it contains more constituents who are members of an ethnic minority group than constituents who are white and non-Hispanic. Now, the standard remedy for a vote dilution claim is the creation of a greater number of majority-minority districts, where the minority group is reasonably assured of being able to elect a candidate of its choice. Again, candidate of its choice harkens back to the actual language of Section 2 itself. But that's difficult to determine at times. I mean, it's easy to say what the standard remedy is, but courts have really struggled over time in determining when vote dilution occurs, and then, of course, determining the specific contours of a remedy. So we're talking about, if you are going to remedy a situation by creating a greater number of majority-minority districts, what does that exactly look like? The devil is always in details there. But again, as I mentioned, the vote dilution can occur in two different instances. The first is packing. So that's when members of the minority group when you pack members of a minority group and you create too few majority-minority districts where minority voters may elect representation of their choice. So that's too few districts. Essentially, that's a situation where the minority group is controlling fewer districts than it could, and so essentially minority votes are being wasted in that scenario. The other scenario is called cracking. Cracking divides the minority group into too many districts where they cannot achieve a majority. So you're spreading out the minority vote into too many districts, and they can't form a working majority in any particular district. So that's packing and cracking. Again, those are examples of how vote dilution could occur. But the question is, what is the legal standard for vote dilution? In other words, what does a plaintiff have to establish if they are going to establish that vote dilution has occurred by a particular voting practice? Now, there is basically a two-step inquiry to determine vote dilution. The first step is based on essentially a three-part test from the Jingles case. These are the so-called Jingles factors or Jingles requirements. And then once that three-part test is satisfied, then you go into a second stage called the totality of the circumstances, which then you consider a bunch of additional factors, which are typically referred to as the Senate factors in that analysis. So you first have to satisfy this initial three-part test, which we'll go over in detail, and then you get the totality of circumstances and have to satisfy that. And at that point is when you've satisfied for the test under Section 2. So what are the tests here? Or what are the steps more specifically? Well, first, the Jingles factors, the question here is the minority population capable of electing a candidate of its choice in a hypothetical district, according to this three-part test? So the three-part test, the beginning of it is that the racial group is sufficiently large and geographically compact to constitute a majority in a single-member district. Then the racial group is politically cohesive, and then that the majority votes sufficiently as a block to enable it to defeat the minority's preferred candidate. And the next three slides address all three of these specifically, so we'll get into the details of these three different factors. But then again, as I mentioned, once you satisfy these three factors, you go into a second stage of the totality of the circumstances, which asks that based on the totality of the circumstances, do the members of the racial group at issue in fact have less opportunity to elect the candidates of their choice? And that again requires an examination of the factors listed in a Senate report that accompanied the 1982 amendment to the Voting Rights Act. And we'll go into those particular factors in more detail in a moment. So let's just start with the first jingles factor, and that's whether the minority group is able to establish that it is sufficiently large and geographically compact to constitute a majority in a single member district. So again, when you're looking at that language, it's referring to two different things. One, it's referring to the size of the minority group. And then second, it's referring to the compactness or the geographical compactness of the minority group. So what does size mean in this context? Well, size typically means that the size of the minority group has to be more than 50% of the voting age population. It's important to note that it is the voting age population that the courts have said to look to when determining this. And so you have to be in a scenario where you're more than 50% of the voting age population. There have then been questions of whether so-called crossover districts or so-called coalition districts would satisfy this size requirement. The crossover district is a district where there's a minority group that can still elect the candidate of their choice with the help of crossover voting from white voters. So that is a minority group along with crossover votes from white voters electing its candidate of its choice. The courts have said that that does not satisfy this particular jingles prong. So that is not a kind of district that would satisfy this. However, courts have indicated that coalition districts, that is a situation where two or more racial minority groups can create a majority together, can satisfy this prong, as long as these groups are sufficiently cohesive. Cohesiveness actually gets into the next jingles factor, but so there's a little bit of an overlap here, and we'll discuss what that means. But that's a way that you can satisfy this size requirement under this particular jingles factor. Second part of this jingles factor refers to compactness, which asks whether the minority community is sufficiently concentrated, taking into account principles as like communities of interest and respecting traditional boundaries. I have a reference here to the LULAC case, which I think is a very interesting case, and it has a good demonstration of this compactness issue. This is a situation where a district in Texas was found to not be compact because it combined Latino voters near Austin and those of the Rio Grande Valley 300 miles away. So you can imagine a district where you had a large Latino population in Austin and in the metro area, and then the district was drawn to include 300 miles away a different Latino population in the Rio Grande Valley. The court found that that was not compact and did not satisfy this particular jingles factor. Now, one of the things, and this kind of is referred to in the LULAC case, but a district is not compact when a hypothetical district can cram together far-flung or politically differing minority groups whose only common index is race. And again, that's coming from the LULAC case, but you're in a situation again where they're far-flung or they're politically differing. You may face this issue under the compactness requirement. Moving to the next jingles factor on cohesiveness, and again, you'll witness some similarities to the first factor, but this is referring to whether the minority group has expressed clear political preferences that are distinct from those of the majority. Now, how do you prove this particular factor if you're a plaintiff? It is typically proven through expert testimony and statistical analysis showing some sort of correlation between minority status and candidate preference. Courts have also indicated that they can consider non-statistical evidence. This basically is observations or experiences of those involved in a particular area. So you can do it both different ways, or two different ways. But expert testimony and statistical analysis is the primary way to demonstrate, again, whether there is a situation where the minority group is politically cohesive. There is, importantly, though, no quantitative threshold for how cohesive a group must be. So the courts have never made that a bright line rule that there's a particular quantitative threshold or statistical threshold on cohesiveness. And the logic here, by the way, is that if Section 2 is to ensure that the minority group can elect candidates that it prefers, and again, that goes back to Section 2 itself, then it must actually have a group preference. It has to have political cohesiveness. The third factor here is majority block voting. So this is similar to factor 2 in some ways. It's sort of the reverse of it. So Section 2 is looking at minority block voting. Jingles factor 3 is looking at majority block voting. And so as a result, what is commonly referred to as racial polarization really is referring to both factors 2 and 3, because it's majority block voting and minority block voting together that come together to be considered as racial polarization. Now, the question in this third factor is whether the white majority votes sufficiently as a block to enable it in the absence of special circumstances, such as the minority candidate running unopposed, usually to defeat the minority's preferred candidate. So you would have to show that. And again, it's typically shown in similar ways as factor 2 through statistical analysis and expert testimony. Now, I'm turning now to the Senate factors or the totality of the circumstances test. But as I mentioned before, you have to satisfy the first 3 Jingles factors, which I've gone through in detail, before you get to this totality of the circumstances test. But if a minority population satisfies all 3 Jingles requirements, then the court examines under the totality of the circumstances as a result of a challenge, practice, or structure, the plaintiffs do not have an equal opportunity to participate in the political process and to elect candidates of their choice. Now, how do you determine this? Well, as I mentioned, in the 1982 amendment to the Voting Rights Act, there was a Senate report that accompanied that amendment that included a bunch of factors to consider under the totality of the circumstances. The Jingles decision actually adopted those specific factors for this portion of the inquiry. I also have proportionality here. Proportionality is referring to the percentage of total statewide districts that are minority opportunity districts with the minority share of the citizen voting age population. So kind of a simplified way of looking at it is, if the minority population in a particular jurisdiction is 30%, well then 30% of the districts should be minority opportunity districts. That's sort of proportionality at its very basic. I have this in here though because it's not a Senate factor, but it is a factor under the totality of the circumstances that some courts consider, in particular the Ninth Circuit. Of course, we're in the Ninth Circuit, so that's important to remember. And the idea of proportionality is that it protects against the state having too many majority-minority districts, because under the law, there is no right to proportional representation under statute. But again, it's a factor to look at and consider under the totality of the circumstances. So what are the actual factors that you have to look at, or I should say Senate factors that you have to look at? And I have the listing of them here. The first is the history of voting-related discrimination in the jurisdiction, and I'll sort of also say that when we're looking at the Senate factors, you'll notice they're a little bit different in that they're a little bit more historically based. So they're looking at sort of the history of a particular jurisdiction. At least some of the factors are than the first 3 Jingles factors. So in the Senate factors, the first one, the history of voting-related discrimination in a particular jurisdiction, the extent to which voting in the jurisdiction is racially polarized. There's 2 of these, by the way, that are sort of the most important, and I'll point them out at the end. The extent to which the jurisdiction has used voting practices or procedures that increase the opportunities for discrimination against the minority group, whether there's an exclusion of members of the minority group from the candidate slating process, if that is a feature of the district, the extent to which the minority group bears the effects of past discrimination in education, employment, and health, the use of overt or subtle racial appeals in political campaigns, the extent to which members of the minority group have been elected to public office in the jurisdiction, and then evidence that elected officials are unresponsive to the minority group's needs, and then finally, evidence that the policy underlying the use of the contested practice is tenuous. Of these factors, the 2 most important ones, at least that the Supreme Court has indicated as most important, are the second one, which is the extent to which voting in the jurisdiction is racially polarized, and then the third to last one, which is the extent to which members of the minority group have been elected to public office in the particular jurisdiction. So they're all factors, but again, the Supreme Court has indicated those 2 are most important. And then the Ninth Circuit, as I mentioned before, has added this additional important factor of proportionality in this analysis. I go into the next slide a little bit more about what I just stated. When you're looking at the prioritization of the Senate factors, there's no single factor that's dispositive, but as I mentioned, there are 2 in particular that the Supreme Court has indicated are most important. And then the question becomes, how do you establish or prove these factors? Well, the factors that deal with racial polarization, you prove them similarly to the Jingles factors. You do that through statistical analysis. The other factors, as I mentioned before, some of these factors deal with more historical facts, are based largely on historical social conditions, and you get an expert, with expert reports or testimony from historians or demographers to talk about those historical or social conditions to establish those factors. So the final section that I'm going to talk about here is racial gerrymandering. I think that's it's important. It's not directly a Voting Rights Act issue, although, like I said, there are some principles that are shared between the two. But it's important to consider because it is possible to face a redistricting plan can face a racial gerrymandering objection or claim against it. So what is gerrymandering? Gerrymandering is the practice of drawing lines that to favor one group over another. Historically, gerrymandering could be considered as either partisan gerrymandering or racial gerrymandering. But under the Rucho v. Common Cause decision from 2019, so a very recent decision, partisan gerrymandering is no longer justiciable. So in other words, you can't bring a partisan gerrymandering case anymore in federal court. But nevertheless, racial gerrymandering remains as something that can be brought. And as I mentioned before, racial gerrymandering implicates the principles of the Equal Protection Clause as well as the VRA. We've seen through modern jurisprudence that there's been a distinction made between racial gerrymandering claims under the 14th Amendment, under equal protection of the clause of the 14th Amendment, and then the VRA claims. And I'll get into it in the next slide, but at times you can view them potentially as being conflicting with each other. So they're seen by the courts as two different types of claims. And as mentioned here, it's often related to vote dilution claims. In other words, the principles will be the same, but it is a distinct claim under the 14th Amendment. So different types of racial gerrymandering. You have negative racial gerrymandering. These are where lines are drawn to prevent minorities from electing their preferred candidates. And then you have the opposite, the affirmative racial gerrymandering, where lines are drawn to favor racial groups. The first modern decision that dealt with racial gerrymandering was Sean v. Reno from 1993. This was in a situation, I have in the graphic here, the particular congressional district. But this is the second, this is in North Carolina. This is a second majority Black district, and the court referred to it as winding in a snake-like fashion until it gobbles in enough enclaves of Black neighborhoods. So you can kind of see just from the map, the unusual shape of that particular district. Now, in that particular case, and this goes back to what I mentioned before about the distinction between vote dilution claims and then racial gerrymandering claims, that particular case, the challengers did not argue that the plan diluted majority voting rights, but that it was an effort to segregate the races for the purpose of voting without regard to traditional redistricting principles and without sufficiently compelling justification. Now going to the last slide, which is a little bit more sort of a practical slide. What would you have to do to show a racial gerrymandering claim or make a racial gerrymandering claim? Well, a plaintiff must show that the redistricting plan on its face has no rational explanation save as an effort to separate voters on the basis of race. So that's something that the plaintiffs would have to show. And it arises in situations where race predominates over other neutral criteria in a redistricting plan. And when I say other neutral criteria, I'm talking about things like compactness, respect for communities of interest, things like that. Now, to withstand a constitutional challenge, the state must show that the plan is narrowly tailored to meet a compelling state interest. So, in other words, the state could rebut a claim that the plaintiff brought that there's racial gerrymandering by determining or establishing that there was a compelling state interest for the particular plan. Now, the case law, as I say here, does not provide bright line guidance on this as far as, the sort of interaction between the VRA and the requirements of the VRA and the 14th Amendment racial gerrymandering claims. So in general, I would say that compliance with the VRA, in other words, drawing majority minority districts, which may be required under Section 2, is a compelling state interest that the particular state can refer to as a compelling state interest in this kind of claim. However, the prevailing view is that a state must comply with the VRA, but do no more than necessary to meet those obligations. So the idea that it's been referred to this way, which I think is kind of a good way to refer to it, is that the 14th Amendment provides a ceiling to the VRA's floor of ensuring adequate minority representation. But ultimately, and with this last bullet point here, it's an important consideration, that states should draw districts with consideration for all criteria. That includes, of course, the neutral criteria, not just race. That's generally guidance that courts have provided in this area. So this is my sort of overview of the various requirements. I don't know at this point, Madam Chair, if you want to entertain questions or move to executive session.
Can I just ask you to repeat you said the 14th Amendment provides a floor. Just repeat that last piece, and then we'll entertain a motion to go into executive session.
Yeah, so it's the other way. So that the 14th Amendment provides a ceiling to the VRA's floor of ensuring adequate minority representation.
Okay.
So what I'm referring to there is essentially that, you know, the VRA can require one thing, for example, drawing majority-minority districts, but one could go too far in doing that in violation of the 14th Amendment equal protection. And so there's this sort of range between the two that, you know, redistricting commission or you know, redistricting legislature would have to consider.
Okay. Unless there are specific questions to the meaning content of a slide, thank you so much for that, you know, substantive presentation. And I will entertain a motion to go into executive session to clarify for the public the rationale for going into executive session, which will not be open to the public, is for the purpose of obtaining legal advice to further implement and or advance the legal issues we are discussing pursuant to ARS 38-431.03A3. And with that, I will entertain a motion to move into executive sessions to apply what we've learned to our own endeavor.
This is Commissioner York, so moved.
Do I have a second?
Commissioner Meal, I second.
Any further discussion? We'll move to a vote. Vice Chair Watchman.
Aye.
Commissioner Meal.
Aye.
Commissioner Lerner.
Aye.
Commissioner York.
Aye, and I also request a 5-minute break.
Absolutely. I was going to say maybe even 7. I don't know, 5 to 7. Maybe we'll compromise on 6. But Commissioner Newberg is an aye. With that, we will move into executive session. We have, I sometimes forget to do this. In terms of moving into executive session, we have the 5 commissioners. We have Director Schmidt, Val, our transcriptionist, and our legal counsel. And I believe that is it. And with that, we will take a 6-minute break. We'll see you soon. Okay, it looks like we have our commissioners, our director, transcriptionist, Val, our attorneys. Is our entire team in place? I believe so. Okay. With that, thank you for the public's patience, and thank you for our legal counsel for entertaining our questions regarding that, very substantive presentation. One follow-up from the conversation, our counsel is going to do additional work on understanding the application of VRA to the Native American population in Arizona. And so we will look forward to that public report in due time. And with that, we will move to agenda item number 8C, which is Arizona Constitutional Redistricting Criteria Requirements presentation. Again, we will start in public session, followed by the opportunity for commissioners to elect to go into executive session to discuss specific legal implications as it relates to our commission. And with that, I believe we're turning it over to Mr. Eric Spencer. And you're on mute.
Chairwoman, can you hear us okay here?
Mm-hmm.
There we go. All right, I'm going to share my screen. Okay. Well, Roy is going to be a tough act to follow, but I will do my best. I'm going to shift into Arizona law and the Arizona Constitution. I have called these clauses that we're going to discuss the mapping clauses. I haven't seen a court or a case call them those, but there are 4 provisions in the Constitution that I'm just going to call the mapping clauses. I'm not going to discuss the other Arizona constitutional provision that guides us because it's coextensive with federal law, and therefore we'll talk about the Equal Protection Clause of the 14th Amendment. But there's a synonymous provision in the Arizona Constitution called the Equal Privileges and Immunities Clause in Article 2. I'm just highlighting it so that you're aware of its existence, but 95% of this presentation is going to focus on the mapping clauses. I think everybody's aware about how those provisions came into being. Prop 106 was passed by the voters in 2000 that amended the Arizona Constitution and created the body of which you've been appointed. And it has complete power to draw the legislative and congressional lines. Other states' commissions have bifurcated those processes. Some states have held on to one of those, but delegated the other. But in Arizona, it's pretty comprehensive. Okay, so this is just a screenshot from the legislature's website. I want to show you where this was codified. On the left side of your screen are the first 15 articles of the Arizona Constitution, and the voters made an amendment here in Article 4. Article 4 has, you'll see in the first 2 items at the top, Part 1, and then the rest of Article 4 is in Part 2. And the voters amended Part 2, Section 1. That provision already existed in the Constitution, but they plussed it up significantly. So here's the structure. Before the voters amended Part 2, Section 1 in 2000, these were the 2 provisions that were in the Constitution. It's that we have a House and a Senate. They can call a special session. And then the voters added about a dozen or more different provisions. These aren't the mapping clauses here. A lot of these you're familiar with because they are what got you into office, about how the IRC commissioners were nominated and selected. There's a few provisions in there about how to fill vacancies. Let's hope that doesn't occur. How our esteemed chairperson was selected and vice chair. We're never going to get into section 10 there, impeachment, but it's in the Constitution. 12 and 13 also are in there, governing how we vote, and some restrictions on what you all can do during and after being commissioners. But then it's 14 through 17 that govern your map drawing process. And those four provisions are what I'm calling the mapping clauses, and we're going to go into those in good detail. And then there's some cleanup provisions that the voters put in there about how we're funded, how we can hire staff, consultants, lawyers, how you can go into court to defend your maps, you can get paid for expenses, and how we end up winding down. So let's get into what these four clauses say. The meat of this is in 14. First of all, the commission is bestowed the authority to do congressional and legislative districts. That's the guide star of your job. It begins with the creation of districts of equal population in a grid-like pattern across a state. That's what we're going to call phase 1. And then you're going to make adjustments to that grid map. There's 6 different criteria. Compliance with the Constitution and the Voting Rights Act, equal population in both the legislative and congressional districts to the extent possible, geographic compactness and contiguity to the extent practicable, respecting communities of interest to the extent practicable, using visible geographic features, city, town, county boundaries, undivided census tracts, again, to the extent practicable, and finally, favoring competition when it wouldn't create a detriment to other goals. Don't worry, there'll be lots of detail here. All right, sticking with my overview in section 15. We can't use party registration or voting history data up front when we're creating the grid maps, but those can come into play later when we're creating the draft maps. Incumbents or candidates where they live never comes into play. I'll go into this in more detail, but consider that completely off limits. 16, we get into our public comment and advertising. You've got to put it out to comment for at least 30 days. Obviously, it could be longer than 30 days. That's a policy decision. I'm sure our calendar might dictate whether we do more than 30 days, but that's the minimum requirement. Not only the public gets to comment during this period, but as we've spoken about in prior commission meetings, the legislature has a constitutional right to submit a memorial, a majority report, a minority report, which the commission is required to consider. And then the last phase here is establishing the final boundaries after you've taken into account the public comment. Finally, section 17, it's self-executing. What that means is that the legislature is not required to go in and further define anything found in the Constitution. I'll talk about a statute that's relevant here in a moment, but this doesn't require any legislative gloss. We're able to direct directly as the voters drafted this. And then finally, we give it to the Secretary of State. Secretary of State will distribute that to the counties and publish new signature requirements and do all of the necessary cleanup work to ingest our maps and let candidates start using and running on those. Now, by the way, I should mention, if you have any questions during, feel free to ask. There's a good chance that I've covered it on a future slide, but this can definitely be an iterative process. This is just a graphical representation about how the timeline is going to go this year. We go from grid maps to draft maps, and between the draft maps and the final maps, we're both getting public comment and the legislature's recommendations. And then finally, we certify this to the Secretary of State. Okay, let me start on the grid map. I think the word grid can connote in common language rectangular or square-shaped patterns, but I want to highlight two things from the Constitution. Not only does it prescribe a grid-like pattern, but importantly, it says equal population. And if we try to divide the state into geographically equal grids, we would by no means satisfy the equal population requirement. And just as a reference, here is a proposed grid map from IRC 2.0 a decade ago on the congressional side. You'll see that the grid does not conform to rectangular or square shapes. So grid, I think the best way to think about the word grid, it means contiguous, that these shapes should be confined unto themselves. And at this point, we don't need to stretch those with loose connections geographically. They should be contiguous plots of land, and the important part here, though, is equal population. So they're going to more look like what you see on the right, and definitely not what you see on the left. So let's talk about how the last commission did the grid maps. There's nothing in the Constitution that prescribes how you do this, but I want to talk about this just to give you an idea about what's been done in the past. On one hand, so this is the congressional map. The last commission created one grid map where they started the numbering in the middle of the state and worked in a counterclockwise direction. You'll see in the southeast corner of the state, Cochise County, that's District 9. They also put out an alternative congressional grid map where they started the numbering in the southeast quadrant and worked their way clockwise around the state. And the final District 9 was in the middle of the state. Similarly, on the legislative side, one of the maps started in the middle and went counterclockwise, because you can't see District 1, but it was essentially in the middle of Maricopa County, and I think in Glendale in this map. And they created another version where they started in the southeast corner and again worked clockwise around the state. There's no right way or wrong way to do it, and that'll be your discretion under the law. I do want to mention something about district numbering. There's not a requirement. Let me go back up just for reference. By and large, these numbers, if you follow them carefully, there is a sequence of numbering. For example, down here, District 1, District 2, District 3, they are adjacent to each other and they do follow a pattern. There's no requirement for you to do that. I'm sure our great consultants at Timmons NDC will have recommendations on that issue. But here are here's a legal consideration for you. There was a great lobbyist for the Prescott area, because in statute, there is a requirement that Prescott be in LD1. Keep in mind, this doesn't apply to the congressional maps, just the legislative maps. But we would be foolhardy to ignore this requirement, and in fact, existing LD1 under the current maps is in Yavapai. It's mostly in Yavapai County and Prescott. Keep in mind the constitutional provision that says that you have to adjust off the grid map. So what does that mean? Our recommendation is that you maintain contiguity when you're moving from the maps. In other words, if you start the Prescott area as being an LD1 right from the get-go, then that will allow you to adjust from the grid map to the draft map, from the draft map to the final map, instead of having the Prescott area be in some other LD and then having to make a leap. And let me show you what I mean here. Here are the two grid maps from the last commission. LD1 was placed in Maricopa County in one and in Cochise County in the other, but Prescott is up there. The Prescott LD15 on the left and what looks like LD14 in the middle, those don't even touch the LD1s created in the the grid maps from a decade ago. And when they went from the grid maps to the final maps, Prescott, of course, is now an LD1, but you can make an argument that the commission did not adjust off of the grid map. Now, at the end of the day, that wasn't challenged in court, and I think the courts would afford you substantial deference. But I just want to flag this issue for your consideration, that we will mitigate litigation risk by really trying to adjust off of the grid map when we get to the draft map. And there's not really a good argument here that LD1 was adjusted. In fact, it was wholesale leapfrogged over to Prescott. Just something to consider. Now, prohibited considerations at this part of the map drawing process. Party registration and voter history. The Constitution says you can't use these in the, quote, initial phase. I think that's synonymous with the grid map phase. So let's assume that to be true. Party registration is pretty obvious what that means. It's who's Republican, Democrat, Independent in each district. Voter history is not defined, but I think a fair a definition of that term is how often people vote, by what method do they vote? Are they early or are they in-person folks? Whether they vote at all. That all can be gleaned from the voter registration file that is acquired from the Secretary of State and or the counties. It's going to be, in fact, parts of this is already in the possession of our mapping consultants, but this is off limits to be used at the grid map stage because we're just looking for equal population. Incumbent residents, this also applies to candidates' residents, but it has much more importance in the incumbency realm. At no time can this information be considered by the commission. Now, the Constitution says identified or considered. This generated some significant litigation in the past, and I'll explain what we mean here. Can our consultants acquire this information? I'm not talking about whether the commission is using it, but can it be in the possession of either your attorneys or your mapping consultants? And the answer is probably yes. Now, these are some excerpts from litigation 16 years ago, and the court cited the arguments of IRC 1.0 about why they acquired information about incumbents' addresses, and it was to test competitiveness. The court did not rule directly on whether it was appropriate to acquire that information, but implicitly it was okay for the ruling I'm about to explain in a moment. But just be aware, we're probably allowed to possess it. But here's the rationale that the Court of Appeals went through in 2005. It determined that it would be completely unworkable to craft a rule that said you are not allowed, you as commissioners are not allowed to possess the information in the first place. Number one, this is going to be everywhere. As soon as the maps, the draft maps are published, numerous media organizations, political parties are going to find out where the incumbents live, and they're going to probably run stories about which existing incumbents might be pitted against each other. And you're not a sequestered jury, you're going to read the news. So that information is going to be out there. Some lawmakers will probably appear at some of these hearings, and if there's a sign-in sheet, either physically at that meeting or electronically as a prerequisite to speak at that meeting, an address might put a lawmaker might put their address down on that sheet. Now, the first commission went through and redacted that from those speaker slips just to be careful. but we would inhibit those lawmakers potentially from attending our meetings and speaking if we were so worried about them giving an address. You're likely to have knowledge about where some of incumbents live, maybe not their addresses, but you probably know what city or town they live in. And you might accidentally get this information, or your staff might get this information. So for all these reasons, the court laid down these tests. You're only prohibited from using these addresses. The goal of the Constitution is to make sure you're not weakening or strengthening a particular party's political base when drawing these districts. For example, intentionally pitting two incumbent Democrat congressional members against each other in order to facilitate retiring one of them. That's totally off limits. And here, what I've underlined in the second quote is the takeaway. The key is knowledge combined with use. And our recommendation here is for the commissioners to never make a request or a direction to our consultants, to your lawyers, to use that stuff. If you know of an incumbent's address, don't mention that during a commission meeting. Don't put that on the record, and just don't consider this at all. We're going to leave it to our mapping consultants to acquire what they need in order to run the reports, or frankly, we might hire other consultants as well, not just mapping. But those experts might need incumbent information to conduct some sort of analysis for some other legal purpose, but it should not ever come from the commissioners. Okay, that was the draft map. I mean, the grid maps. Let's move on to the draft maps. I mentioned this before, but I want to emphasize this. The Constitution says you need to adjust the grid. Now, there was litigation in the last decade about the maps created by IRC 2.0. And I've got an excerpt here from a Superior Court ruling. This is not binding. This is persuasive, but not precedential. But I think it's instructive. What the court concluded was, let me give a little bit of background. The prior commission, I would say, had some difficulty in creating a compromised set of maps. There was some acrimony involved, and I think the clock was ticking. And so a compromise effort was made where maps were proposed that incorporated comments that had been made in prior meetings, but they were swapped in. And that process of swapping in these proposals were created offline, arguably did not constitute an adjustment from the grid. There was not a time, to my knowledge, where the grid was displayed on the screen and this boundary was moved here and this boundary was moved there, and an adjustment was taking place. Instead, there was a substitution of maps. The court, to be very clear here, upheld what the last IRC did. It held that it does not mandate, the Constitution that is, does not mandate that we show our work to that nth degree, but it created a litigation issue. And we would avoid quite a bit of litigation potentially if we were faithful to this proviso that you have to adjust the grid map. The court, a decade ago, a decision was in 2017, but the court basically said that adjustments to the grid maps were discussed extensively in open meetings. And while there was no physical display where those boundaries were being adjusted, the record was, according to the trial court, replete with information about the decision-making calculus that the last commission went through in order to metaphorically adjust the grid map into the draft maps. So I'm just flagging this issue for your consideration. and we'll have additional detail for you in executive session on that topic. Now, getting into compliance with the Constitution and the Voting Rights Act. Thankfully, Roy took care of half of this for me. The two constitutional provisions to be aware of are the Equal Protection Clause in the 14th Amendment and the Apportionment Clause in Article 1, Section 2 of the Constitution. I've only got one slide on this, but I want to flag some of the potential issues. Equal protection is probably going to be the most likely constitutional argument, I think, that any commission would get. I mentioned this earlier. It's been interpreted by our courts to be under the same standard as our state constitution's equivalent. So if someone were to sue, they would probably allege violations under both the federal and the state constitutions. But all of the case law comes from federal, and that's what the court will probably focus on. There's a few different types of potential violations to be aware of. We're not going to commit any of these, but this is what the menu looks like for potential plaintiffs. One is impairing the right to vote. This is also a right guaranteed by the First Amendment. So when I see litigation in this area, the cause of action is titled burdening the right to vote or impairing the right to vote under the First and 14th Amendments. But for this purpose, I'll just discuss the 14th Amendment. If it's a substantial or severe burden on the right to vote, then the court will subject this to strict scrutiny. Three different types of scrutinies exist. Rational basis review, which is the least restrictive. You just have to have a logical rationale for doing what you do. There's intermediate review, which doesn't really come up in redistricting. I see that applied in gender-based decisions in other areas of the law, but I haven't seen that come up in redistricting. So let's ignore that for this purpose. But if the burden is severe, then strict scrutiny would be applied. That's very difficult to survive. You have to have a compelling government interest in doing what you did, and you have to have chosen the most restrictive and narrow means possible to accomplish your goal. So a lot of the game there is trying to convince a court that it should or should not be evaluated under a strict scrutiny standard. But I flag this as a type of cause of action to be aware of. Another one is a decision based on race or some other suspect class like nationality. If race is used as a predominant factor in drawing districts, then you've also got a potential equal protection violation, and you're also going to potentially subject that to a strict scrutiny analysis. There are, I think, as intimated in Roy's presentation, there is a give and play between what you can and can't do in this area. Compliance with the Voting Rights Act is traditionally recognized as a reason why race might need to be taken into account. In fact, a lot of the litigation of the last decade was about whether Commission 2.0 allegedly overcomplied with the Voting Rights Act to the detriment of this provision. But now this is where racial gerrymandering comes into play. Roy's excellent presentation described what that means. But if someone accuses a commission of racially gerrymandering, then this is the component of a 14th Amendment equal protection claim that they're going to make. As Roy mentioned, political gerrymandering, though, is not justiciable. You can't go into court and argue that a commission was unduly motivated to help a particular political party. That's not something that's recognized anymore. As for legislative districts, a component of the 14th Amendment is something recognized over the last 50 or 60 years, and that's the one person, one vote principle. This is most recently reaffirmed in a case coming out of the last commission, Harris versus IRC. If someone complains that our legislative districts are not sufficiently equal, they would allege a one-person, one-vote claim under the Equal Protection Clause. We're not going to go there, though. Finally, this is a claim alleged during Commission 1.0 in the 2000s that the IRC's declination to formally adopt definitions of certain terms in the Constitution, such as a community of interest or substantial detriment. Those plaintiffs alleged that the failure to adopt definitions caused that commission to engage in arbitrary decisions, which allowed some folks' rights to be burdened more than other voters' rights or citizens' rights, and that was an alleged equal protection violation. But that claim was shut down in a 2005 appeals court case. So the top three here are the most likely types of equal protection claims that a commission could see and that we would obviously seek to prevent. Under the apportionment clause of the Constitution, this is what governs population equality for congressional districts. Remember, legislative districts have to be equal based on the 14th Amendment. Congressional districts have to be equal based on Article 1, Section 2 of the Constitution. And that has consequences, which I'll get into a bit more when we get into the equal population section of the presentation. But these are the basic U.S. constitutional provisions that we need to comply with. Luckily, I get to skip this slide on Voting Rights Act because Roy did such a great job. Okay, now we're in the second prong of the mapping clause. Congressional districts and legislative districts shall have equal population. How close to equal must it be? Congressional districts have to be as close as we can possibly get to equal. It doesn't have to be perfect, but we need to try to be perfect. Here are some excerpts from various Supreme Court cases decided over the years. And I think the Kirkpatrick case is a good one. The standard requires that we make a good faith effort to achieve precise mathematical equality. These other experts make clear that some deviations might exist in reality, and to the extent there is a deviation in population equality for our congressional districts, we've got to justify that. We've got to have a really good reason why we couldn't achieve population equality. Again, I'm not talking about the grid map here, I'm talking about the draft map for congressional districts. This is a very high standard that we need to meet. For legislative districts, since the requirement stems from the 14th Amendment, not from the Constitution, there is a bit more flexibility in the deviations in population that can occur between legislative districts. A rule of thumb is that they can vary by up to 10%. So, for example, if we've got the population that the Census Bureau has computed for the state of Arizona, we divide that by 30 for our districts. That's the perfect number of persons that should be in each legislative district. One district might be 3% below that, and there might be another district that is 3.5% above it. In trying to use all of these constitutional factors, communities of interest, compactness, there could be a hypothetical scenario where you might need one district at -3 and the other one at +3.5. That collectively is a 6.5% deviation, and that, as a default matter, is probably constitutional under the law. But if you get close to these boundaries, you're increasing your chances of litigation. So we would obviously be very careful if we begin to get up to the 10% range. But we've got a bit more flexibility. Okay, going into the third mapping factor. Districts must be geographically compact and contiguous. This is about the district shape. You think about it, a compact district that is contiguous will inhibit, if not prevent, gerrymandering, because the requirement, for example, to connect parts of the district with another reduces the ability to gerrymander, and you keep the communities of interest together. So this has an effect on some of the other factors in the Constitution. What does compactness mean? That's the length of the borders. So just add up the geographic length around the borders. The shorter the distance around the district, the more compact it is. Contiguity means the connection, uniting the district. We can't have either congressional or legislative districts that are completely separated without anything in between connecting them. So what's the minimal connection that is necessary for it to be contiguous? There's been some litigation on this issue. In the first go around in IRC 1.0, the court issued a decision that said it just needs to be, to the extent practicable, striking a balance. The court won't second guess that balance as long as you had a reasonable balance, a reasonable basis for your decision. So you have to be able to articulate why you did it that way. Here's an example from 20 years ago. This isn't too easy to see, but in the right side of this map in black is the Hopi tribe. It's surrounded by the Navajo reservation. The area in the middle in white is still District 1 back from the 2000s. That's part of what the Navajo Nation is in. And on the far left, the upper left corner, is the parts of District 2. So you can see here that the Hopi tribe was put into District 2, and that very thin line of contiguity is the Colorado River running through the Grand Canyon. The plaintiffs in that first decade alleged that this district, District 2, was not sufficiently contiguous because contiguity in their mind meant accessibility. It needed to be a road, for example, that is capable of being traveled. And the Court of Appeals rebuffed that notion and held that contiguity does not mean accessibility. And the court upheld the maps. So you don't need to have the ability to traverse the area, and this river connection was enough. Now, it's up to you whether, from a policy perspective, you want to have a connection between districts that is more fulsome than what was accomplished here. But this was deemed to be constitutional. Communities of interest, the fourth criteria in the Constitution. Now, I've created a definition here. This isn't drawn from Arizona law, but I think this is a good way to think about the concept. It's a geographically cohesive and connected population that has a common set of concerns, where this community would benefit being grouped into the same district. There could be multiple ways where this community is united, whether ethnic, racial, religious, even lifestyle or economic interests, or even rural, urban. You are required, so the town halls we're going to do in the next couple weeks are designed to identify and better flesh out what this concept means. And you'll get some great information about what the communities of interest are. But this is a working definition to think of. You can't interfere with communities of interest to the extent possible. Now, does that mean you can't ever split a community of interest? No. The proviso that it be to the extent possible or to the extent practicable respected means there can be cases where a community of interest is divided, and there's been some litigation on that. Putting an entire community of interest in one district is the most commonly thought of way to respect it, but it's not necessarily the only way. Again, 20 years ago, the Navajo Nation sued over the maps that were created And if you go back to that map I showed you a few slides ago, when connecting the Hopi tribe to then District 2, that river connection swept in 42 members of the Navajo Nation and put them in the same district as the Hopi tribe. The commission did its best to minimize that, but in the end, the court held that it was appropriate to respect the Hopi tribe's community of interest by not only keeping it cohesive with other Hopi members, but to separate it at the time from the Navajo Nation. So it was okay and deemed to be somewhat de minimis that a portion of the Navajo Nation's members were split off because the commission was accorded deference in its decisions that respecting the Hopi tribe's community of interest and separating it from the Navajo Nation was important. These are policy decisions that you're going to have to make, but I show that case to demonstrate the deference that you'll be accorded, as long as you show your map. Okay, visible features. This is the fifth component of the mapping clause. Visible features are like mountains, streets, roads, streams, railroad tracks. You can see these can be naturally occurring, geographic, or they could be man-made. A census tract is a subdivision of a county, uniquely numbered. There's usually about 4,000 residents or 1,600 housing units. In a moment, I'm going to show you some census tracts in Maricopa County, just to show you how numerous they are. So when can you divide a census tract? It's almost the same logic as why you're allowed to divide a community of interest. It could be to accommodate a different constitutional goal. The first IRC was sued on this basis, very much tied into the Hopi tribe Navajo Nation dispute going on, or the claims made in that case. And not only was there litigation about whether or not those two districts were contiguous enough, but there was a census tract that was split as well, and the court upheld that for largely the same reasons why it upheld the district shape. Here's just an example in Maricopa County alone. I'm sure our great consultants will do their best not to split tracts, but there is a lot of them, so that's no easy task. Finally, we're on the last item mentioned in the mapping clauses, dealing with competitive districts. You'll see this is phrased a little bit differently than the other goals, and I'll explain why that's the case. What is competitiveness? It's trying to have a relatively even partisan balance where there is a heightened chance that one party or another has a shot at winning that particular race. It's the opposite of a safe district, where the outcome cannot basically be foreordained based on party registration. You're going to hear a presentation from, actually multiple presentations from some experts over the next couple weeks and from our mapping consultants about potential different ways that competitiveness can be measured. These are just some buzzwords of different competitiveness measures that you might hear from. There's probably 100 different potential measures. We're going to narrow it down to a handful that are worth considering. You might hear the academic literature on that issue. You might hear the author, or you might just hear our great folks from Timmins NDC. But you're going to be presented a range or a menu of different ways to measure competitiveness. And here's the great news. You're not limited. Let 1,000 flowers bloom is a phrase that recently expressed to Brett and I think it's a good example. So you'll choose which measures of competitiveness you want to use. You can use as many as desired, and the court, the Supreme Court in 2009, the Arizona Supreme Court said that your choice of competitive measures is entitled to deference. In fact, they said it's outside the scope of judicial review. You can also combine some of these or use some averages. But we're going to get some great feedback from our mapping consultants on what to use. So what's the role of competitiveness versus the other 5 goals in the Constitution? What is clear from the first appellate case in 2005 is that you cannot ignore this issue altogether. In the first go-around of IRC 1.0, the Commission produced a set of draft maps where it did not take into account competitiveness. Then there were some preclearance issues with the DOJ where they objected to a few districts in the legislative map. And for reasons that would take too long to explain, the IRC went and created another set of maps. And in the second go-round, they did include a competitiveness analysis. And so they in essence cured the problem from their first advertisement. It's just best practice to make sure that we have accounted for all of the constitutional goals before we put these out for public comment. Now, here's what has best been described by our appellate courts. Achieving competitiveness is mandatory but conditional. And I want to read this quote because it was first cited by the Court of Appeal in 2005, and it was directly reproduced by our Supreme Court in 2009. If drawing competitive or more competitive districts would not be practicable or would cause a detriment to the other goals in the Constitution, the Commission must refrain from establishing such districts. Conversely, if it would be practicable to draw competitive or more competitive districts, and doing so would not cause a significant detriment to the other goals, the Commission must establish those districts. The conditional nature is what separates this from some of the other 5 goals. The Supreme Court has disavowed thinking about competitiveness as a subordinate goal. And I think it imposes the wrong frame of reference if we try to figure out whether or not it is equal with other goals or whether it is not equal. I think that's just the wrong way of looking at it. It is a mandatory goal, but it is conditional. Let me give you an example. If the Commission is faced with keeping the Navajo Nation and respecting it as a community of interest into one district, but doing that requires the population between that district and an adjacent district to be unequal, that's a policy decision that the Commission is allowed to make. It can place a higher premium, if it so decides, to respect that particular community of interest, even though it might cause some detriment to contiguity or some detriment to equal population. It could even do that if it caused a significant detriment to population equality or contiguity. Constitution allows you to do that, but competitiveness is different. If the Commission was faced with the decision to split the Navajo Nation into 2 different communities of interest in order to favor competitiveness, it cannot do that because this is the one area of the Constitution where you cannot cause significant detriment to the other goals. So in the example I just gave you, while you could play around with the criteria and make these policy decisions after a lot of thought and deliberation, playing around with communities of interest and population and compactness, You really can't do that with competitiveness. You have to try to make it more competitive if you can do it and it won't significantly affect the other criteria. In the first go around of the commission, the plaintiffs alleged that the commission didn't make any objective findings that the other goals were not, would be significantly, would have suffered from significant detriment. That commission didn't go on the record and say, I hereby find that a community of interest would have significant detriment, therefore I refuse to make this district more competitive. The court held, the Supreme Court held that you need not be that explicit. You need not make such an objective finding on the record. It's probably a good idea, but those maps couldn't be thrown out 2 decades ago because that wasn't on the record. The record demonstrated that the court took competitiveness into account during its meetings, and therefore the Supreme Court upheld that. I think the new Supreme Court is probably going to tend in this direction as well. I think I have another slide on this issue, but let me mention it here. The definition of what constitutes significant detriment is yours to decide. There's not case law on this issue, and the courts are going to defer to your determination about whether increasing the competitiveness of districts will cause significant detriment to some other goals. It's a good idea to voice that on the record and describe your thinking on it, but there is no objective standard from the law that defines what significant detriment means, so you're going to be able to decide what it means. Here are some other things that need to be taken into account. I know this presentation won't go on much longer, but I know you're so enthralled that you don't want it to end. At the draft, Brett does. At the draft map stage, here you can consider party registration and voting history. Remember, we're beyond the grid maps. We're at the draft maps now, and it's perfectly appropriate, in fact, necessary to think about those things. How do you balance these 6 goals? That is a good policy debate, but our courts have given us some direction, which I think may be helpful. Your decisions are accorded substantial deference. You were put here to exercise your judgment and weigh those goals against each other. In fact, the court in 2005 said that the voters, the people, have entrusted you, a politically balanced group of 5 individuals, with the discretion about how to reach reasonable conclusions. You're allowed to give more emphasis to one goal or another. You can prioritize communities of interest over contiguity or compactness. That's your decision to make. You can't ignore the Constitution. You must follow the procedures in the Constitution that I've outlined. And you have to apply your work in a rational way. So there's still some guardrails, quite a bit of guardrails on what you do. But at the end, you're a legislative body. What about your personal knowledge? Courts have looked at this. We accept that you bring personal knowledge and experience into this task. In fact, I would call that a benefit. Maybe that's why you were selected, because you come from such diverse experiences. That's a welcome part of the process. But the courts have said, we're not going to knock you for bringing your personal knowledge or experience into this. So you're allowed to do that. What about the courts? How much are they going to get into second guessing you? It's not the role of the courts to change or improve your plan or determine whether or not it can come up with a plan that is superior. I think we're going to see a lot of this just based on history. We're going to get hundreds or thousands of maps from the public, which is a great thing. But some of the litigation after IRC 1.0 was a contention by some litigants that commission could have made the maps more competitive than they were, without necessarily sacrificing any of the other constitutional goals. And the court ruled that that is not the standard. Think about how endless litigation would be if someone had standing to come in and present a map to a court saying they did it better than you did. That would just be an impossible situation to manage. So you're going to take into account those incredible suggestions that we're going to get from the public, and the appropriate time to take in those account is prior to finalization of the maps and certification of Secretary of State. But litigants can't go into court and say they could do better than you. To be fair, though, the court will still review the process in which you've created the map. A legislature normally is not subject to that review. A court, for example, will not get into whether or not the Elections Committee in the House of Representatives or the Judiciary Committee in the Arizona State Senate went about passing a law, or whether it cut off debate or didn't follow its own rules. The courts don't get into that. But here, while you are treated like a legislative body, the courts will supervise the process in which you did create the maps. So it's not unfettered. What standard is the court going to use? I already got ahead of my skis on this, but you need to have a rational, reasonable basis for doing what you did. The court is going to walk in and presume that what you did is constitutional. So the wind is in the face of challengers, and it's at our back. And as I mentioned before, the plaintiffs can't come in with a better map and assume a court will just adopt it and say thank you. This last point has not been addressed by courts. It's really a policy decision. The Constitution doesn't tell you that you have to complete both the legislative and the congressional maps at the same time and put them out for the same 30-day period of comment. I think that's probably how both prior commissions have done it, maybe for efficiency purposes. But it's your decision as to which of the two maps you're going to create first. And secondly, are you going to send those out for public comment simultaneously, or are you going to send them out serially? And that's just a policy decision for you. But I flag that. Advertising. Promise we're almost done here. How are you going to receive public comment? I think that's a great discussion to have with our Timmins NDC folks, with Executive Director Schmidt and his staff. We're going to get barraged here. I don't know whether receiving comments through email and the website are going to be the right way to absorb all this information, but that's something to think about. How do you ingest this massive amount of data in a way that makes it meaningful for you to not only understand, but to potentially incorporate into your final revisions before going to the final map? How are you going to record all the town hall information? You're also probably going to hold hearings. I suspect you're going to hold hearings after the draft maps have been published. Probably those will be in person to some degree, just like the town halls. How are you going to record all that data? Something to think about. All right, legislative recommendations. You, as a body, must consider the legislative leadership's comments and maps. There's been some litigation on this. What does it mean to consider it? A plaintiff cannot come into court and simply disagree with how the IRC used the legislature's recommendations or what weight should be attached to those recommendations. That's a policy decision for you. These are judgment calls, and if you want to accord 1% or 99% weight to what the legislature says, that's your decision. Now, there was litigation in the last decade about whether IRC 2.0 had sufficiently considered the legislature's recommendations. The record in that case mentioned by the trial court, again, we don't have an appellate decision on this. This is just what the trial court ruled in 2017. But those legislative leaders, then President Biggs and Minority Leader Campbell, presented to the commission in person. They took questions from the commission, and the court basically said that was enough. They submitted the legislature submitted reports, and the trial court ended up deferring that the IRC 2.0 had sufficiently deferred. Okay, we're in the final stretch. There's almost nothing in case law about the final maps. You just need to incorporate the comments, recommendations, and approve them. Send them to the Secretary of State. We've already been in discussion as a staff with the Secretary of State about how the maps are going to be provided to them, in what format can the Secretary of System accept that format and be distributed to the counties. So we've had some good preliminary coordination on that. And obviously you'll try to make your best efforts to meet the Secretary's preferred deadline. Why is January 2nd an inflection point? And that's because if the maps come out before January 2nd, those new boundaries are what the signature calculations to get on the ballot are going to be based on. The maps come after January 2nd. I believe the candidates for the next election are going to use the existing previous numbers to guide their signature calculations. There's already a bill that's been passed that gives some flexibility here, but that's an aspirational goal. Okay, that was the most enthralling presentation you've heard. And if the commission would like to have a couple, I'm sure you need a break, by the way. Madam Chair, it's up to you whether to take a couple public questions here or whether you want to recess and go into executive session, but we're happy to answer in public, won't get us in trouble.
Thank you for that substantive presentation. If there are any specific, questions that relate to specific content, I'll open it up to my fellow commissioners. If not, I will open it up to a motion to move to executive session for us to be able to apply this information to our specific work. Again, just to be clear to the public, the rationale for going into executive session, which is not open to the public, is for the purpose of obtaining legal advice to further implement and/or advance these legal issues pursuant to ARS 38-431.03A3. So unless there are any specific questions, I will entertain a motion to move into executive session.
This is Commissioner Lerner. I move to executive session.
Do I have a second?
Commissioner Meal seconds.
Any further discussion? Vice Chair Watchman,
Aye.
Commissioner Meal,
Aye.
Commissioner Lerner,
Aye.
Commissioner York.
Aye.
Commissioner Newberg is an aye. With that, we will move into executive session, and with us will be Val, Director Schmidt, our broader team, and our legal counsel. We will take a 6-minute break, and I will see my partners in executive session. And regarding the public, it should not be more than, let's say, 15, 30 minutes. Who knows? Would not be that long. We'll see you soon. Okay, I believe I see our broader team. Thank you, everybody, for your patience. I see all commissioners. If I could get a confirmation that council staff is all reconvened. I believe I see our team. With that, I'm going to thank everybody for your patience. It provided us an opportunity to ask just meaningful questions. I think everybody would agree that these presentations today really speak to the heart and soul of what we're doing. I think the presentations will be posted online if they are not already. And I encourage anybody, if you've not seen it, or to please encourage your contacts to look at the material. It will better inform our community for the basic principles as we move forward with, I think, some important decisions. With that, we will move to agenda item number 10, which is discussion of future agenda item requests. We have already alerted everybody that we would like, or we're anticipating listening to presentations on the pros and cons with differential privacy on the 13th. We have some specific requests from our mapping team. Are there additional agenda items that we have not yet identified that the commissioners would like to propose?
This is Commissioner Lerner. Just, I think that's only about a week, 10 days before our first public meeting. So if we could have a detailed presentation on how our public meetings will be held and any information that would be helpful for all of us as well as the public. And if there's anything that can be published prior to our meeting, if it's available online for people to know location. I know you don't have those yet when you get them, but I think anything that we can have on that that's more specific would be helpful. Thank you.
We will aim to provide on our agenda on the 13th very specific guidelines, because you're right, it's I think 9 days or something like that before our first meeting. Any other requests? Okay, with that, we will move to agenda item number 11, discussion and possible action on the scheduling of future meetings. As a reminder, we will be observing July 4th next week, and we'll have our first day off. I wish everybody a wonderful holiday and enjoy the time. And we will plan to reconvene at 8 a.m. on July 13th, Tuesday, our normal time. With that, agenda item number 12, announcements. I don't have any announcements. Director Schmidt? Okay. Agenda item 13, next meeting date is July 13th, 8 a.m. Agenda item number 14, closing of public comments. Please note, members of the commission may not discuss items that are not specifically identified on the agenda. Therefore, pursuant to ARS 38-431.01H, action taken as a result of public comment will be limited to directing staff to study the matter, responding to any criticism, or scheduling the matter for further consideration and decision at a later date. With that, we move to agenda item number 15. I will open up a motion to adjourn.
So moved, Vice Chair Watchman.
Do I have a second?
Second, Vice Chair York, Commissioner York.
Quick vote. Vice Chair Watchman.
Aye.
Commissioner Meal.
Aye.
Commissioner Lerner. We didn't hear you. Sorry. Okay. Commissioner York.
Aye.
Commissioner Newberg is an aye. With that, we will adjourn. Let's root for the Suns, so by next week we're in the finals. We'll see everybody next week.
Go Suns.
Okay. Bye-bye, everybody.